Imagine driving home late at night, the road almost empty, your music blasting so loud the bass rattles the windows. You are lost in the beat, and then suddenly flashing red and blue lights appear in your mirror. Your heart jumps. Do you pull over right away, or do you keep going those last few seconds to reach your driveway? You choose home, roll into your garage, and hit the button to close the door behind you. But before it shuts, the officer slips in, blocks it with his foot, and suddenly he's standing inside your garage. The big question is simple: is that legal? That exact moment led to one of the most important unanimous decisions the Supreme Court has made in years. In a 9-0 ruling, every justice agreed that this kind of warrantless entry raised serious Fourth Amendment concerns. It was not just a technical detail, it was a test of whether the home still stands as the strongest shield of privacy against government intrusion. The case was called Lange v. California. Back in 2016, Arthur Lange was driving home in Sonoma, California. Sonoma is not a place where traffic hides misbehavior. It is quieter with vineyards and calm neighborhoods. Lange had his windows down, music up, and according to reports, he was honking his horn for no clear reason. A California Highway Patrol officer noticed, followed him for a while, and eventually switched on the lights to signal a stop. But by then, Lange was already turning into his driveway. He drove into his garage, pressed the remote, and the door began to close. The officer jumped out, blocked the door, and entered without a warrant. Inside, he questioned Lange, claimed to smell alcohol, and soon charged him with driving under the influence. But the core issue was not drinking. The core issue was whether the officer could lawfully enter that garage without a warrant. The Fourth Amendment is clear. The home is where privacy rights are at their highest. For centuries, courts have said your house is your castle. Unless there is a true emergency, the government cannot just walk inside. The officer and the state argued that he did have that power because of the hot pursuit doctrine. That doctrine allows police to chase someone fleeing and follow them into a private place without stopping for a warrant. Historically, this applied to felony serious crimes, where hesitation might mean danger to the public or destruction of critical evidence. Think of a robbery suspect running into a building. The officer cannot be expected to pause and ask a judge for permission. But Lange was not suspected of a felony. At most, his offenses were misdemeanors, playing loud music, honking, and possibly failing to stop right away. If hot pursuit automatically covered every misdemeanor, then the protections of the Fourth Amendment inside the home would shrink dramatically. Every noise violation, every traffic infraction, every minor misstep could be the doorway to police entering a house without judicial oversight. That was exactly what the lower courts decided in California. They sided with the officer. They said that because Lange had not stopped when signaled he had committed a misdemeanor, and because the officer was in pursuit, he could follow into the garage. It was a broad interpretation, and if left standing, it meant almost any chase, no matter how minor, could end with the government inside your home. Lange appealed, arguing that this turned the Fourth Amendment into a hollow promise. The point of the amendment is to protect the private sphere of the home. If officers could claim hot pursuit for even the smallest violations, then most Americans would lose that shield. After all, most crimes in the United States are classified as misdemeanors. That would mean that the vast majority of police encounters could lead to warrantless entry. This argument worked its way up through the system until in 2021, the Supreme Court agreed to take the case. The justices now faced a clear question. Does the hot pursuit of a misdemeanor automatically justify entering a home without a warrant, or should there be limits to protect the heart of the Fourth Amendment? When the Supreme Court finally took this case, the stakes were obvious. If California's view stood, police could follow anyone into their homes for almost any minor violation. Think about rolling past a stop sign, turning music up too loud, or taking a little too long to pull over. Under that theory, each of those small actions might open the door for law enforcement to step directly into your house without a warrant. In 2021, the justices listened to both sides. California argued that once someone ignores an officer's command to stop, they are fleeing. Officers, they said, need clear rules, not hesitation. A simple standard, if you are in pursuit, you can enter, was easier to apply in the real world. They warned that if police had to stop and weigh felony versus misdemeanor, important chances to protect the public could be lost. Lange and his attorneys argued the opposite. They reminded the court that the home has always been the strongest shield of privacy. The founders had lived under governments that entered houses at will, and they wrote the Fourth Amendment to prevent exactly that abuse. By definition, misdemeanors are lower-level offenses. They usually do not involve danger or urgency. Treating them the same as felonies would collapse a key distinction in criminal law and drain the Fourth Amendment of meaning. The hot pursuit doctrine already had precedent. In United States v. Santana, 1976, the court said officers could follow a felony drug suspect into her home without waiting for a warrant because evidence could vanish in seconds. but that case dealt with a felony. The court had never drawn a clear line for misdemeanors, and lower courts disagreed. Some allowed warrantless entry, others did not, and California took the broadest path pursuit for any offense. That uncertainty is why the Supreme Court agreed to step in. In June 2021, the ruling came down. All 9 justices sided with Lange. Their decision was clear. There is no automatic rule that hot pursuit of a misdemeanor justifies entering a home without a warrant. Instead, courts must consider the totality of the circumstances. That phrase became the anchor of the opinion. Judges need to ask, was there an actual emergency? Was anyone in danger? Was evidence at risk of being destroyed, or was the offense minor with no pressing reason to enter? To make sense of it, picture 2 examples. If a driver is suspected of drunk driving and swerves dangerously into their driveway, the risk to public safety might justify immediate entry. But if a driver honks too long at a red light and then goes inside, that alone does not create urgency. The difference is not the technical label of misdemeanor. It is whether the circumstances create real danger or urgency. Even though the decision was unanimous, some justices wrote concurring opinions. They agreed with the result, but gave slightly different reasoning. A few stressed the historic sanctity of the home in Anglo-American law. Others focused on the risk of abuse if officers had a blanket rule. But across the spectrum, from conservative to liberal, the court stood together. California's rule went too far. This outcome was more than a technical win. It reinforced the idea that the home is still the core of privacy under the Fourth Amendment. Without this ruling, most Americans could have faced warrantless entry for minor issues, since the majority of crimes in the United States are misdemeanors, traffic violations, noise complaints, small licensing problems. If every one of those opened the door to hot pursuit warrants, would have become almost meaningless. The court's decision also reshaped how lower courts handle these situations. Judges can no longer rely on a one-size-fits-all rule. They must evaluate details. Was there a chase that posed real risk? Was violence likely? Was there imminent loss of evidence? Or was it simply a small violation where the officer could wait for a warrant? That case-by-case approach requires more effort, but it keeps the balance between safety and liberty intact. For people worried about government overreach, this was a huge relief. It showed that even in a divided political climate, all 9 justices could come together to protect the home from unnecessary intrusion. And in the realm of constitutional law, a 9-0 ruling sends a message that could not be stronger. So, why does this case matter today? It is not just about one man in Sonoma or one officer stepping into a garage. It is about a principle that touches nearly everyone. The Fourth Amendment is meant to protect the home as a sanctuary, a place the government cannot enter without a warrant. If the court had ruled the other way, that line between public and private space would have blurred almost beyond recognition. Consider how many laws count as misdemeanors. The list is long: noise violations, jaywalking, traffic infractions, expired tags, minor possession of contraband, even failing to leash a dog in some cities. None are violent crimes, none create emergencies. Yet under California's approach, each could have justified entry if a person happened to step inside before stopping. That loophole would have weakened the Fourth Amendment to the point of being almost meaningless. That is why the court's insistence on a case-by-case approach matters. The phrase totality of the circumstances may sound like legal jargon, but it really means looking at the facts. Was there immediate danger? Was there an urgent need to act? Or could the officer have simply waited outside and sought a warrant? By forcing courts to answer those questions, the ruling preserved the balance between public safety and individual liberty. Convenience for the government is not a valid reason to erase constitutional rights. The decision fits into a wider pattern. Just months before the court decided Caniglia vs. Strom, rejecting the claim that officers could enter a home under a broad community caretaking theory. Taken together, these rulings send a clear message: the home is different. Whatever exceptions might exist in public, the threshold of a residence demands stronger protection. And the story continues. After Lange, another case gained attention: Case vs. Montana. That challenge also deals with warrantless entry, and the Supreme Court has scheduled arguments to decide how far Fourth Amendment protections extend. Observers see it as a chance to reinforce what Lange and Caniglia already established. The trend is clear: the court is reluctant to weaken the shield around the home. For gun owners, the relevance is immediate. In states with strict firearms rules, many technical violations are misdemeanors: storage requirements, transport rules, magazine limits. If police could use those as reasons to step inside homes without warrants, entire groups of people would face constant risk. Lange closed that door. It confirmed that small infractions cannot be transformed into a free pass for searches and seizures. But this case matters even beyond firearms. It matters to parents who want their children safe at home. It matters to renters who deserve peace of mind. It matters to anyone who believes the government should be bound by law, not guided by convenience. The principle is universal. The home is the core of privacy, no matter who you are. The phrase "your home is your castle" has deep historical roots. It goes back to English common law centuries before the Constitution. The idea was simple. A dwelling was a fortress, shielded from intrusion even by the crown. The founders carried that belief into the Bill of Rights. When the court in Lange reaffirmed it, they were not inventing something new. They were defending an old truth that remains essential in modern America. The lesson is straightforward. Constitutional rights are not just abstract promises. They are protections that apply in real situations, even when the story begins with something ordinary like loud music and a garage door. Without vigilance, rights fade often through small exceptions that seem harmless. With vigilance, they endure. The ruling in Lange v. California may not have dominated headlines, but it deserves attention. It stopped a dangerous expansion of power and proved that the Fourth Amendment still has force. Whether you care about firearms privacy or simply the idea that your home is sacred, this was a victory worth remembering. And it stands as a reminder that the walls around you are not just materials. They are boundaries the government cannot cross without first answering to the Constitution.